Yes, here we are. Thank you. Well, court has finished. And interestingly enough, at 9:30 tomorrow morning, it's on. It's on tomorrow morning. So today was just a procedural. So today's was just very much a very short procedural matter to work out how it's going to go. So let's have a look what happened. So first of all, Judge O'Callaghan accepted the transfer of the file from the federal family court, the court that it was in. He has accepted that transfer, and so now it's in his hands. So at 12 o'clock today, DJOKOVIC is going to have his documentation filed and ready to go. By 10 o'clock tonight, the government is going to respond and have all of their documentation in. So they've got a very, very tight turnaround time because court starts 9:30 tomorrow. Now, unfortunately, I've got church, so I'm not actually going to be able to watch it. So the hearing was adjourned. Now, what is really interesting, so it was very much procedural, so it was very short. So this is how the ABC summarized it. So, yep, so it's going from the federal circuit and family court to the federal court. And this is the question, this is the sticking point, the question of whether this needs to be held in front of one judge or a full court. Now, this is really, really interesting because DJOKOVIC's lawyers would like it to be a full court. The government has stated that it only needs one judge. Now, here's where it gets really interesting. If it goes before a full court and DJOKOVIC loses, when it's before a full court, you actually lose the ability to appeal. Now, this is really what's interesting. If it's before one judge and DJOKOVIC loses, he can appeal. But if it's a full court and he loses, he gets deported. So I found it very interesting that it was DJOKOVIC's lawyers pushing for the full court, knowing that the process of appeal diminishes. Now, the government's reason for opposing the court was that they were actually saying, the government said that if it's before a full court, the applicant would not be able to appeal, and they thought that they should have the right to appeal if he lost it. So anyway, the Justice O'Callaghan, His Honour, has actually reserved that right to make a decision. He's not decided. There will be a decision sometime today as to whether that is before a full court. And I guess it comes down to whether or not they can, how many judges they can round up on for 9:30 on a Sunday morning. Let's face it, you know, he's going to need to work out whether he is he's going to be able to. Oh, look at this. There's documents here already we can review. Look at this. All right. So they also said that they were happy for the files to be put onto public record. So we've got the order from Judge Kelly yesterday. So here is the application. They're going to amend it by lunchtime today. They're going to correct spelling stuff. I didn't know that either, Bo. It's very interesting. The government's trying to show that they're being fair because they're trying to say, well, you know, he needs to be able to appeal. So this was filed yesterday, last night. So this was the original processing. This was the original process filed in the Federal Circuit and Family Court of Australia. So they are going to amend it so that it's appropriate now for the federal court. So the hearing should be expedited because the subclass 408 visa that was cancelled was granted in order to allow the applicant to compete in the Australian Open 2022, which starts on the 17th of January. The applicant contends that the purported decision made by the respondent on the 14th of January 2022 under Section 133C3, read together with Section 1161EI of the Migration Act, to cancel his visa is invalid. The applicant respectfully requests that the application be heard urgently, such that if the application is successful, the applicant may be able to compete at the Australian Open. That is that. So the final orders, they want the order of the decision to be quashed. They want any injunction or writ of prohibit restraining the minister from making further decision or taking other action subject to the proceedings. They want an order that the respondent is to take appropriate steps to ensure that the applicant is released. They want costs, etc., etc. So now, here's their case. So now they've started the case about the 5th, the 6th, about his visa, the first unlawful decision, they're calling it. So remember, then they've got that was quashed, and it says about at or about 1746 on the 14th of January 2021. It should be January 2022. They did state that they were going to go through and that there were some mistakes in it, and they were going to fix them. The minister purported to cancel the applicant's visa under Section 1133C3 of the Act, second purported decision. Section 113C3 required the minister to be lawfully satisfied in order to have power to cancel the applicant's visa under the subsection that a ground for cancelling the visa under Section 116 of the Act existed, and it would be in public interest to cancel the visa. See, for me, it's interesting that it says lawfully satisfied, because to me it just says satisfied. That would be my first, I know, but anyway. The minister produced reasons for his purported decisions. In his reasons, he recorded that he'd received advice from the Commonwealth Department of Health that on the assumption that Mr. Djokovic had tested positive for COVID-19 on the 16th of September, negative on December 22, and was asymptomatic on the 27th of December, he was a low risk of transmitting COVID to others, and the risk of transmission, and that the risk of a transmission event into the Australian Open is very low. He assumed that Mr. Djokovic posed a negligible risk of infection to others, assumed that Mr. Djokovic had a medical reason for not being vaccinated, assumed that Mr. Djokovic entered Australia consistently with the TARGI documents, found that Mr. Djokovic had made no attempt to contravene any Australian law, was of good standing, and was known for his philanthropic efforts. Despite these findings, the minister nevertheless found that Mr. Djokovic's presence in Australia may be a risk to the health of the Australian community, may be a risk to the good order of the Australian community. In each case, the minister's reasons were founded in at least substantial material of propositions that in April 2020, well before COVID vaccines were available, Mr. Djokovic said he was opposed to vaccination. Mr. Djokovic had previously stated he wouldn't want to be forced by someone to take a vaccine, to travel or compete in tournaments. The material makes it clear that he's publicly expressed an anti-vaccination sentiment. In any event, inferentially, his sentiments would be perceived in that way. Accordingly, his presence in Australia may foster anti-vaccination sentiment, which, if they were to occur, would have deleterious effects identified. These findings, hello, Terry C. These findings form part of the basis for the finding at D that Mr. Djokovic's presence in Australia may be counterproductive to the efforts of vaccination by others in Australia. In the same way, the minister found in relation to good order standing that having regard to inter alia, his publicly stated views as well as his unvaccinated status, his presence in Australia may pose a risk to good order. That's a thing. Physics down under, I've not seen any of that. I've not seen anything addressing those. I've not seen anything about the fact that he had COVID and was out and about in community. Because as far as I'm concerned, that to me, they're arguing that it doesn't. Well, I've not seen the document the minister produced, but that's what I would say. He poses a threat because he had COVID and he was out in the community. But anyway, in the same way, the minister found in relation to good order that having regard. And yeah, so it's the same or similar reasoning appears in regard to the minister's approach to public interest in the matter, reasoned as follows. Despite my acceptance that above that Mr. Djokovic's recent infection with COVID-19 means that he is at a negligible risk of infection and therefore presents a negligible risk to those around him, I'm concerned that his presence in Australia, given his well-known stance on vaccination, creates the risk of strengthening the anti-vaccination sentiment in the minority of the Australian community. What about the fact he lied on the documents, Minister? Ah! Stated that the good health and order points discussed are each separately relevant to whether it is in the public interest to cancel Mr. Djokovic's visa. In a sentence, the minister's reasoning in regard to all of risk of health, risk to good order, and public interest involved the proposition that Mr. Djokovic's presence may cause an increase in anti-vaccination sentiment, in effect, because he may be perceived by some talisman of a community of the anti-vaccine sentiment, leading to various negative consequences. Hello, Poppy Seeds. We're reading the application. We're reading the originating application, which has just been posted on the federal court site. The minister has not, from what I can see, used anything to state about the fact that he didn't follow rules, that he didn't isolate when he had vaccine, you know, that he travelled. But so remember, his lawyers have to make him look like has to make the government look like the bad guy, and you know, they've got to find holes in his. Yes, I did follow the hearing this morning. Yes, I did. I'm interested in your thoughts about the full court or a single court judge. I just found it interesting that Djokovic, that his lawyers are happy for a full court because the option of appeal goes away. I would have thought he'd want to have the option to appeal if he lost. Because if he loses, he's out. So the first ground, they're saying illogical, irrational, unreasonable. Well, I thought so too, physics down under. I thought because it was under Section 3 where there was where natural justice does not occur, if the minister decided to. The word is, it's about the word satisfied as far as I'm concerned. If he's satisfied, then you're out. But anyway. So they're saying it's a logical, irrational, unreasonable approach to one or more of the Section 116 precondition, the question of public interest, and the exercise of discretion. So the minister's decision to cancel or not cancel had binary legal outcomes. If the minister did not cancel Mr. Djokovic's visa, then Mr. Djokovic would be entitled to remain in Australia, present in Australia in accordance with the conditions of his visa, or if the minister did cancel Mr. Djokovic's visa, then Mr. Djokovic would not be entitled to remain present in Australia, and instead he'd be liable to detention and forcibly removal from Australia, as well as subsequent inability to apply for certain visas and precluding him from obtaining certain visas for a period of 3 years, except in certain circumstances, including the minister being satisfied that there were compelling circumstances affecting the interests of Australia. If he loses, he's got zero. They want to limit the minister's ability. Oh, okay, if they win. But I mean, of course, they're assuming they're going to win, but then they also could be shooting themselves in the foot as well. It's a very interesting, yeah, it's a bit of a risk they're taking, isn't it? Accordingly, which is the underpinning of the minister's reasoning, Mr. Djokovic is perceived by some as a talisman of a community of the anti-vaccination sentiment, then the question of whether Mr. Djokovic's presence in Australia may foster anti-vaccination sentiment, and if so, the significance to that assessment of public interest, and the exercise of discretion could not logically, rationally, reasonably be assessed in isolation from, without also considering the question of whether the cancellation and consequent detention and forcible removal of Mr. Djokovic, being a person who the minister recognised had the characteristics at 10 above, on the basis of a few lines of text that he said 2 years ago, may also foster anti-vaccination sentiment. And if so, significance of that to the assessment of public interest and the exercise of discretion, especially in circumstances where the only evidence before the minister as to the behaviour of the anti-vaccination activists in relation to Mr. Djokovic was evidence that the first unlawful decision, being a decision of the same consequence as the second purported decision, was to really galvanise anti-vaccination activists. Hello, Short Order Cook. The minister did not consider the question identified at 18b above. In the circumstances, the second purported decision is affected by a jurisdictional error. All right. Here's the thing that I'm really interested in. For me, the clear issue was the fact that he had COVID. He was out in a community affecting other people with COVID. He lied on his documents were not filled in truthfully or correctly. And yet it seems that, and again, Djokovic's, this is the grounds that they're taking. I haven't seen the minister's decision, so I don't know what else is in there. He may have put that in there, but they've picked out this section. I don't know. I've not seen the decision. I don't think the decision is going to be made public, though. Ground 2, not open to find the presence of Mr. Djokovic in Australia is or may be a risk to the health or good order of the Australian community. I might also like to add that Bernard Tomic just tested positive to COVID. Everybody that was on that court have had to have COVID testing. And that was before the rules were changed. The rules have just changed again. But everybody on that court has had to isolate and get tested, and they've had to deep clean that court. So there are further ramifications on that. So anyway, that's just a side note. And my third point is, my final point is, do we actually believe the evidence that he gave? The minister cited no evidence that supported his finding that Mr. Djokovic's presence in Australia may foster anti-vaccination sentiment. I didn't believe that he had to provide evidence. Is that correct, Poppy Seeds? The minister doesn't need, where there's no natural justice applied, he doesn't need to give evidence. Is that correct? And it was not open to the minister to make that finding, which finding was material to the minister's purported states of satisfaction that, yes, states of satisfaction. The presence of Mr. Djokovic in Australia may be a risk to the health of the Australian community. The presence of Mr. Djokovic may be a risk to the good order of the Australian community, and it would be in the public interest to cancel Djokovic's visa. In the second circumstances, the second purported decision is affected by a jurisdictional error. As far as I'm concerned, he could have just gone, see, public interest to cancel Mr. Djokovic's visa because he's got an election to win. Right. He doesn't need to give the visa holder opportunity to comment before cancelling. And he did, though. So, Poppy Seeds, does that give more weight to his decision because he took into account Djokovic's documentation? I guess that's what, if he's already seen, if he took documents from Djokovic, which he didn't need to do, he's already gone over and above the requirements of what he had to do. Does that make it more so this morning, they opposed to the affidavits because they've not technically been read yet, but apparently the applicant wants all the documentation out there, so everything's been made public. Taking documentation, well, that's what I would have thought, but they're doing it anyway. So this was for the Federal Circuit Family Court of Australia. Then, yeah, so that's what he's going to argue. Okay. So I'm a partner of the firm Hall & Wilcox. So this is the the lawyer, this is the instructing solicitor, and the partner of the former firm, Will and Hallcox, the solicitor. There's 267 pages. I have carriage of this proceeding. The following facts and matters are set out in this affidavit are within my own personal knowledge. Is a bundle of correspondence received from the Australian government solicitor in respect to respond. Oh, it might be in here. So, alrighty, let's have a look. Because this is on the public record, I'm assuming that this can be all done, and they've not redacted anything. A decision has been made to cancel Mr. Djokovic's visa. Ms. Bannister of your instructions will be provided with relevant documentations. At the conclusion of the proceeding of this court, should the visa be cancelled again, that has now happened, with his visa being cancelled by Minister Hawke today. Thank you. Yes, I know, it's 250 pages, poppy seeds. Notice of cancellation. A notice of decision made by Minister Hawke to cancel Mr. Djokovic's visa. As advised orally at 5:35 p.m, Mr. Hawke has now decided to cancel his visa. A letter of notification for Mr. Djokovic is attached, sent to you as his legal representation. Together with a copy of the submissions provided to the minister when he was considering whether to cancel your client's visa, and the minister's statements of reasons. We will send you a single. Anyway, that's that. They've redacted the password. The attachments and submissions to the minister are rather large. Well, they have redacted stuff. Okay, so stuff has been redacted. So obviously, it's an 8-page submission. Very sad. Notification. So here's the notification. So this is what happens when you get notification. Mr. Novak Djokovic. I'm writing to advise that your Class GG subclass 408 temporary activity visa granted on the 18th of November 2021 was cancelled on the 14th of January 2022 by the Minister of Immigration, Citizenship, Migrant Services. Whatever. Under this section 133C3. I figured that. May make a personal decision to cancel a visa without notice if the minister is satisfied that a ground for cancelling the visa under section 116 exists, and the minister is satisfied that it would be in the public interest to cancel the visa. The attached statement of reasons sets out the minister's decision in your case and provides particulars. The decision to cancel your visa has been made by the minister personally, while the Administrative Appeals Tribunal has the power to review decisions to cancel or refuse a visa made by delegates of the minister. It cannot review decisions made by the minister personally. Under section S113F4 of the Act, the minister has the power to revoke his decision if you make representations in accordance with the invitation and you satisfy the minister that the ground for cancelling the visa referred to in the subsection 113C3 doesn't exist. So how do they make representations then? Because it was the minister. A copy of section 113C is attached pursuant to section 113F4. You're invited to make representations to the minister about the possible revocation of the decision to cancel you. Since the minister may revoke his decision only if you satisfy him that the ground for cancelling the visa under section 116 does not exist, any representations you make should be directed to that matter. Should you wish to make representations about the revocation of the cancelled decision. So are they essentially wasting their time in court, poppy seeds? Because according to this, it cannot review decisions made by the minister personally. So it says, if you decide to make representations to the minister, you may send by mail to the complex and controversial cases section. So that's how they do it. If you believe that you may not have received a complete set of documents pertaining to the original decision, please contact this office. So, considerations. Oh, okay. So they have the right to appeal to the court, not to the tribunal. Okay, right. So only the federal court can reverse the decision. Okay. Alrighty. So no, exactly, short order cook. And it could be a hostile. The reasons get technical, heads up. Okay, well, poppy seeds, it's probably a good thing that you're here. You can decode it all for us, hey? All right. So this is consideration. So the minister may cancel a visa held by a person if the minister is satisfied that the ground for cancelling the visa under Section 116 exists, and the minister is satisfied it would be in the public interest to cancel the visa. Section 1161 of the Act provides, subject to subsections 2 and 3, the minister may cancel a visa if he or she is satisfied that the presence of its holder in Australia may or is or may be or would or might be a risk to the health, safety or good order of the Australian community or a segment of the Australian community. By operations of Section 113C4, the rules of natural justice do not apply to a decision under subsection 113C3 of the Act. I understand while an obligation to accord procedural fairness is not imposed, that does not preclude me from seeking information from the visa holder in relation to a decision under this power. If I make a decision under Section 113C3, the person concerned must be notified of the decision in writing, including particulars of the relevant information, and be invited to make representations about the revocation of the decision. Under subsection 113F4 of the Act, I may revoke a decision if the person makes representations in accordance with the invitation and the person satisfies me for the ground for cancelling the visa referred to in subsection 133C3 does not exist. So as Poppy Seed said before, he doesn't actually have to seek information from the visa holder, but in this case he did, which the government will argue that he had all the information in front of him to make a considered decision. I'm aware that the delegate made a decision on the 6th of January 2022 under Section 116 to cancel Mr. Djokovic's visa, and that the cancellation decision was quashed by the Federal Circuit and Family Court of Australia on the 10th of January 2022. At the conclusion of the proceedings, the court was informed that I would be considering whether to exercise a personal power of cancellation under Section 113C3 of the Act. Following the outcome of the FCFCA proceedings, Mr. Djokovic's visa ceased to be cancelled. He was released from immigration detention and now in the community. Subsequently, Mr. Djokovic's legal representatives have provided lengthy submissions and supporting documentation concerning the possible cancellation of his visa under Section 113C3 of the Act. In those submissions, Mr. Djokovic takes issue with the possible use of the Section 133C3 power, rather than proceeding under a process in which Mr. Djokovic would have the right to be heard before a decision is made. I chose to proceed under Section 133C3, having regard to the need to consider possible cancellation of the visa quickly, in light of the particular circumstances of the case and the public interest in resolving the matter expeditiously. But it took him 4 days. That public interest includes the upcoming start of the Australian Open, the prospect of litigation challenging my decision, and the desirability, if possible, of affording the court time to hear arguments and make its decisions, and a situation where Mr. Djokovic is in the community while he may be at risk to health and good order. Further, Mr. Djokovic had opportunities to put forward his position in documents to the court and in further submissions provided by his legal representatives to me. In case there might have been anything else Mr. Djokovic wanted to say but has not said, I have done my best to consider matters alive to the fact, in fact, Mr. Djokovic's view may not have been sought on everything. My power to cancel a person's visa under Section 133C3 of the Act is subject to two conditions. The first is that I must be satisfied that the ground for cancelling the visa under Section 116 of the Act exists. The second is that I must be satisfied that there would be in the public interest to cancel the visa. Once I'm satisfied of these conditions, I may decide to cancel the visa. Section 1161EI of the Act provides that the Minister may cancel a visa if he or she is satisfied that the presence of its holder in Australia is or may be or might be a risk to the health, safety or good order of the Australian community or a segment of the Australian community. Yes, physics down under, the word is satisfied. If you look at section, this is the Act 113C, section 3, the Minister is satisfied. It's down to satisfaction, and this was my argument. Who am I to say that the Minister's satisfied or not satisfied? Anyway. I can't get no satisfaction. Anyway, by the way of background, a note, so this is 10 pages long, by the way, that Mr. Djokovic arrived in Australia on the 5th of January 2022 to compete in the 2022 Australian Open Tennis Tournament. He's present in Australia during that time in which the Australian community is experiencing a significant and rising number of COVID-19 cases and an active, vocal minority of people in the community opposing vaccination or compulsory vaccination against COVID-19. During an interview with an officer from the department on 6th of January 2022, Mr. Djokovic stated that he'd not been vaccinated against COVID-19. That Mr. Djokovic had not been vaccinated against COVID-19, information that was also included in Mr. Djokovic's Australia travel declaration. Mr. Djokovic also provided copies of his COVID-19 tests, being a positive polymerase chain reaction test. Is that what it means? There you go. Dated 16th of December, and a negative PCR test, the result dated 22nd of December, and a positive COVID RGB-IG test, which seems to confirm that Mr. Djokovic was identified as having a recent or prior infection. The date's 23rd of December. Mr. Djokovic also provided a testimonial from Associate Professor Verika Djokovic, dated 12th of January 2022, which states that Mr. Djokovic's positive test results sampled on the 16th of December and subsequent negative test results sampled the 22nd of December are legitimate. Associate Professor Joanne also stated that our test system is reliable, accurate, and the test results of Mr. Djokovic are legitimate. Mr. Djokovic has provided me with substantial volume of journal articles, medical studies, and medical evidence. He asserts that these materials demonstrate, we're going to fit in the footnote. These materials were attached to emails sent on behalf of Mr. Djokovic on the 10th of January 2022 at around 6:36 p.m. An email sent on the 11th of January 2022 around 11:06 a.m. An email sent on 11th January 2022 around 12:44. An email attaching a letter sent on the 11th of January 2022 at around 12:57. An email attaching a letter sent at 9:24 on the 12th of January. An email sent at 10:51 on the 12th of January. And an email sent on the 13th of January around 11:12 a.m. So, all right. So he asserts that these materials demonstrate that Mr. Djokovic poses a negligible threat of infection to others. He contends that the risk of him infecting others is less than, or at least, no. I've not seen anything about a full court. Haven't seen that decision yet, or at least they're very comparable to that of any other persons referred to in the 5.3a of biosecurity entry requirements, determination 2021. That is, a person who received a course of vaccination with one or more accepted COVID-19 vaccines and received the last vaccination at least 7 days before the last day of international flight was scheduled to commence. There is evidence that the vaccination following a recent infection with COVID-19 may result in more severe adverse side effects. Mr. Djokovic contends that he is at risk of suffering more severe adverse side effects from vaccination because he has recently been infected with COVID-19. And Mr. Djokovic argues that the risk of suffering more severe side effects as a result of his recent infection with COVID-19 is itself a medical contradiction against vaccination. I also received advice from the Commonwealth Department of Health on the 11th of January 2022, which was cleared by the Chief Medical Officer of the Commonwealth on the assumption that Mr. Djokovic tested positive for COVID-19 on the 16th of December, tested negative for COVID-19 on the 22nd of December, was asymptomatic from at least the 27th of December, and is not vaccinated against COVID. The health advice concludes that Mr. Djokovic is unlikely to be infectious with COVID, and as such is likely to constitute a low risk of transmitting COVID to others. This assessment applies to all other demographic groups. Having regard to specific additional control measures applicable to the Australian Open, it is assessed that the risk of transmission, that the risk of a transmission event related to the Australian Open is very low. Well, hello. Yeah. Staff are going down like flies, but okay. I have not saw or read the actual medical material that Mr. Djokovic provided to me, which underpinned his contentions, because I am not medically trained. Nor am I sure if the health advice from the Commonwealth Department of Health and the Chief Medical Officer was given aware of the various medical material relied on by Mr. Djokovic. If there is a difference between the health advice in referring to a low risk and a very low risk, and Mr. Djokovic's contention that he poses a negligible risk, I will therefore proceed on the assumption in his favour that he poses a negligible risk. I have also not saw or read the extensive factual materials that Mr. Djokovic has provided on whether recent infection with COVID-19 is a medical contradiction against vaccination, because I am willing to assume in the time available that Mr. Djokovic has a medical reason for not being vaccinated. I will also assume that Mr. Djokovic entered Australia consistently with ATAGI documents. I'm aware that there was a dispute about this in the FCFCA in relation to the delegate's decision. For present purposes, I will assume that Mr. Djokovic's position is correct, rather than seeking to get to the bottom of this here. I weigh this against cancellation both at the public interest stage and the discretion stage. That I am assuming he currently has a medical reason not to be vaccinated does not ultimately affect my reasoning on good health and good order, explained below. Further, I have had regard to the fact that he received a letter from Tennis Australia, which was signed by Dr. Carolyn Broderick and reviewed by an independent expert medical review panel comprised of, and they've redacted names. I've taken into account upon the receipt of this letter, Mr. Djokovic considered that he had a valid medical exemption to come to Australia, and that he would therefore be entitled to remain in Australia. I give this factor some weight in the exercise of my discretion against cancellation. Although I make the assumptions above and accept that Mr. Djokovic poses a negligible individual risk of transmitting COVID-19 to other persons, I nonetheless consider that his presence may be a risk to the health of the Australian community. In respect, I have given consideration to the fact that Mr. Djokovic is a high-profile unvaccinated individual who has indicated publicly that he is opposed to becoming vaccinated against COVID-19. Mr. Djokovic has previously stated that he wouldn't want to be forced by someone to take a vaccine to travel to tournaments. I have not sought the views of Mr. Djokovic on his present attitude to vaccinations. Even acknowledging this, the material before me makes it clear that he has publicly expressed anti-vaccination sentiment. Further, just as important is how those in Australia may perceive his views on vaccination, rather than his presently held opinion, should it be different from what had been previously identified. I attach information from the Commonwealth Department of Health, cleared by the Chief Medical Officer. Immunisation is one of the most successful public health interventions in the past 200 years. The Australian government has supported immunisation and has strongly encouraged vaccination in the context of SARS-CoV-2. Vaccination was the fifth element of Australia's COVID-19 vaccine and treatment strategy, released in August 2020. The strategy supports early access to the delivery of safe and effective COVID-19 vaccines and treatments. It was developed to provide Australians with a safe and effective vaccine under the targeted and responsive national COVID-19 vaccination policy and immunisation program based upon up-to-date health advice. COVID-19 vaccinations provided. Someone was telling me that he's going to have trouble playing in the US Open because they have the same policies. But anyway, COVID-19 vaccinations provided significant protection against infection, transmission, severe disease, against earlier variants. This protection was viewed as an extremely important managing transmission and also in protecting individuals. The community health system capacity and the economy. The Omicron variant has impacted vaccine efficacy, and the current vaccines now provide less protection against infection and transmission, but do continue to provide significant protection against severe diseases. This protection is essential to protect individuals from severe disease and also from the resultant morbidity and potential mortality. In the context of widespread community transmission and large case numbers, vaccination remains essential in preventing health system overload related to presentations of people with severe COVID-19 disease. The ATAGI also stated on December 24 that strong evidence has accumulated over the past 2 weeks to indicate that booster doses of COVID-19 vaccines are likely to increase protection against infection with Omicron variant, although some early data suggests that the risk of hospitalisation due to disease caused by the Omicron variant is lower than what it was with the Delta variant. This difference would not be enough to offset the impact of high case numbers on our health system. Because of this, I consider that Mr. Djokovic's presence in Australia may pose a health risk to the Australian community. That in that his presence in Australia may foster anti-vaccination sentiment, leading to other unvaccinated persons refusing to be vaccinated, other unvaccinated persons being reinforced in existing view by not becoming vaccinated, and or a reduction in the uptake of booster vaccines. Specifically, this may lead to one or more of the following: an increase in the anti-vaccination sentiment being generated in the Australian community, leading to others refusing to become vaccinated or refusing to receive the booster shot, a reinforcing of the views of a minority of Australian community who are at risk of contracting COVID-19, as to which there are media reports that some groups opposed to vaccination have supported Mr. Djokovic's presence in Australia by reference to his unvaccinated status, an increased number of people deciding not to receive their booster, unvaccinated persons becoming very unwell and or transmitting it to others, and increased pressure placed on the Australian health system, a significant contributing factor being the number of unvaccinated people contracting COVID-19 and requiring medical attention. I have given some consideration to the fact that there is evidence to suggest that Mr. Djokovic has in the past shown apparent disregard for the need to isolate following receipt of a positive COVID-19 test. There it is. And there it is. It's funny that his lawyers didn't address this part. I have also given consideration to the fact there is evidence to suggest Mr. Djokovic has in the past shown an apparent disregard for the need to isolate following the receipt of a positive COVID-19 test result. On December 18, 2021, Mr. Djokovic knowingly attended an interview and photo shoot with Ella Quick. He states that he ensured that he was socially distanced and wore a mask, but he did not wear a mask while his photograph was being taken. Mr. Djokovic has publicly acknowledged that it was an error of judgment to attend this interview, and he should have rescheduled his commitment that he had received a positive test result beforehand on the 17th of December 2021. That's right, we got to the point that we wanted. Given Mr. Djokovic's high-profile status and position as a role model in the sporting and broader community, his ongoing presence in Australia may foster similar disregard. Yes. As I said, it's funny that his lawyers didn't tackle that part of it. So given Mr. Djokovic's high-profile status and position as a role model in the sporting and broader community, his ongoing presence in Australia may foster similar disregard for the precautionary requirements following the receipt of a positive COVID-19 test in Australia. In particular, his behaviour may encourage or influence others to emulate his prior conduct and fail to comply with appropriate public health measures following a positive COVID-19 test result, which itself could lead to a transmission of the disease, a serious risk to their health and others. I consider this to be an additional factor contributing to the possible risk of the health of the Australian community. Accordingly, I am satisfied. Remember, he only has to be satisfied. Accordingly, I'm satisfied that the presence of Mr. Djokovic in Australia may be a risk to the health of the Australian community. I am satisfied because his presence in Australia may be counterproductive to efforts at vaccination by others in Australia, which may lead to may be at risk to the health of the Australian community. It is also reported that in June 2020, Mr. Djokovic organised the Adria Tour, a charity tennis exhibition series in Serbia and Croatia. Media reports suggest that the event lacked social distancing protocols and resulted in a cluster of COVID-19 cases, including the infection of Mr. Djokovic and his wife. While these media reports are concerning, I have ultimately not given weight to this incident because it is not clear that any of the alleged failures comply with social distancing protocol and other public health precautions were endorsed or encouraged by Mr. Djokovic personally. Separately, and quite independently from health risks referred to above and summarised in paragraph 22, I consider that Mr. Djokovic's presence in Australia may be a risk to the good order of the Australian community. In Tian versus Minister for Immigration, described the expression good order and used section 1161E in these terms: an element of risk that the person's presence in Australia might be disruptive to the proper administration or observance of the law in Australia, or might create difficulties or public disruption in relation to the values, balance, and equilibrium of the Australian society. It involves something in the nature of unsettling public actions or activities. So further, in Newell versus Minister, satisfaction might be based on the risk of an adverse reaction by certain members of the Australian society to his presence in this country, rather than on concern about the likely or possible conduct of the applicant in Australia. On the 18th of March 2020, the Governor-General declared that the human biosecurity emergency exists regarding the listed human disease, human coronavirus with pandemic potential. The human biosecurity emergency period is currently in force until the 17th of February 2022. Did you know that? I bet you. It's funny that the media's all over it when Victoria wants to extend theirs, but it's funny because we're under the emergency as well, federally, until the 17th of February. COVID-19 has entered Australia and represents a severe and immediate threat to human health in Australia, as it has the ability to cause high levels of morbidity and mortality and to disrupt the Australian community socially and economically. With the rising case numbers and increased pressure on the health system, it is important that the General Community act consistently with requirements, recommendations, and advice by the Commonwealth, state, and territory governments in responding to the COVID-19 pandemic. I consider that the orderly management of the pandemic by the Commonwealth, state, and territory governments is a component of the good order of the community, particularly bearing in mind the adverse community-wide consequences of failure to appropriately manage the consequences of the pandemic. In broad terms, Commonwealth, state, and territory governments' approaches to managing the pandemic have involved a number of aspects, including vaccination, testing, compliance with social distancing, and other various public health and safety measures. Consequently, I consider that behaviour by influential persons and role models, which demonstrates a failure to comply with or disregard of public health measures, has a potential to undermine the efficacy and consistency of the Australian government's and state and territory governments' management of the evolving COVID-19 pandemic. As noted above, Mr. Djokovic is such a person of influence and status. Having regard to matters set out above regarding Mr. Djokovic's conduct, after receiving a positive COVID-19 result, his publicly stated views, as well as his unvaccinated status, I consider that his ongoing presence in Australia may pose a risk to the good order of the Australian community. In particular, his presence in Australia may encourage other persons to disregard, act in consistency with public health advice and policies in Australia, including but not limited to becoming vaccinated against COVID-19 or receiving a booster shot. In addition, I consider Mr. Djokovic's ongoing presence in Australia may lead to an increase of anti-vaccination sentiment generated in the Australian community, potentially leading to an increase in civil unrest of the kind previously experienced in Australia with rallies and protests, which themselves may be a source of community transmission. I consider those rallies and protests involve something in the nature of unsettling public actions or activities, as described by Goldberg J in TN. It's interesting because there was a rally and protests outside when he was detained, and there was no social distancing or masks either. I also consider that there may be a risk of an adverse reaction by some members of the Australian community to Mr. Djokovic's presence in Australia on the basis of their concerns about his unvaccinated status and his apparent disregard for the need to isolate following the receipt of positive COVID-19 tests. These opposing reactions may themselves be a source of discord and create public disruption. Mr. Djokovic has attracted a high level of press coverage and public interest at a critical juncture in the government's management of a rapidly evolving public health emergency. Accordingly, I'm satisfied that the presence of Mr. Djokovic in Australia may be a risk to good order of Australian community. I have considered whether it would be in the public interest to cancel Mr. Djokovic's visa in accordance with subsection 133C3B of the Act. The Minister is satisfied that it would be in the public interest to do so. In considering the public interest, I have considered that unvaccinated persons create a greater health risk of contracting COVID-19 and spreading COVID-19 to others than vaccinated persons, either of which would further the burden of the Australian health system. Despite my acceptance above, Mr. Djokovic's recent infection with COVID-19 means he's at a negligible risk of infection and therefore presents a negligible risk to those around him. I'm concerned that his presence in Australia, given his well-known stance on vaccination, creates a risk of strengthening the anti-vaccination sentiment of a minority of the Australian community. I note that the costs associated with treatment for those affected with COVID-19 are substantial. COVID-19 cases are having significant impact on the health system in all states and territories, with significantly reduced medical resources in intensive care units and beds availability. Mr. Djokovic has previously indicated publicly that he was opposed to becoming vaccinated against COVID-19 and has acknowledged that he knowingly failed to isolate following a receipt of a positive COVID-19 test. In light of Mr. Djokovic's stance on vaccination and acknowledging failure to follow precautionary measures following the receipt of a positive COVID-19 test result, I consider that cancelling his visa would be consistent with the Australian government's strong stance on the benefits of vaccination and appropriate measures directed to the COVID-19 management. Further, the health and good order points discussed above are each separately relevant as to whether it is in the public interest to cancel Mr. Djokovic's visa. The health and good order of the Australian community are matters of public interest. In a letter dated the 11th of January 2022, Mr. Djokovic raises the following arguments as to why he considers it would not be in the public interest to cancel his visa. He poses no risk to public health and safety. He has made no attempt to contravene any Australian laws. Well, he did, but anyway, he's a person of good standing and a diplomat of the nation of Serbia. In addition to being the best tennis player in the world, he's known for his philanthropic efforts, including his generous donations towards coronavirus relief, as well as towards Australia's bushfire relief. There is support in Australia and a board for Mr. Djokovic to remain in Australia and play in the Australian Open in 2022. Really? He hasn't seen social media. Cancelling Mr. Djokovic's visa would likely to adversely affect Australia's global reputation and call into question its border security policies and procedures. Cancelling Mr. Djokovic's visa would prejudice Australia's economic interests and jeopardise the viability of Australia continuing to host the Australian Open. Cancelling Mr. Djokovic's visa would create an appearance of politically motivated decision-making. I have considered the points raised by Mr. Djokovic. Without intending to be exhaustive, I make the following comments on the specific points raised. The issue of whether he poses a risk to public health and safety has been addressed above. I acknowledge that he has personally made no attempt to contravene any Australian law, that he is a person of good standing and is known for his philanthropic efforts. I acknowledge that there is also some support in Australia and a board for Mr. Djokovic to remain in Australia and compete in the Australian Open. It's interesting that he said some. I acknowledge that there are some diplomatic considerations, which I addressed below. I do not accept, however, that cancelling Mr. Djokovic's visa would create the appearance of politically motivated decision-making, or that it would call into question Australia's border security policies and principles. I also do not accept that cancelling Mr. Djokovic's visa would prejudice Australia's economic interests and jeopardise the viability of Australia's continuing to host the Australian Open. I also acknowledge that Mr. Djokovic is now in the community and that some unrest has already occurred, such that it is too late to avoid it. This weighs in my mind against the public health interest in cancellation. In addition, that's right. That to me was the strongest point, was that he had already contravened rules, but they've gone for this reasoning for some reason. So in addition, as mentioned above, I weighed the issue about whether Mr. Djokovic entered Australia consistently with the target documents as a factor against cancellation. On balance, I consider that the points against cancellation mentioned above, including those raised by Mr. Djokovic, are outweighed by the other public interests mentioned in paragraphs 39 to 43 above, notwithstanding the issues raised by Mr. Djokovic and the substantial impact that the cancellation decision would have on him as an individual, which is discussed in part 3 below. I have given significant weight to the matters of public health and good order discussed above, which are separately relevant to whether it is public interest to cancel his visa. These matters go to the very preservation of life and health of members of the general community, and further are crucial to maintaining the health system in Australia, which is facing increasing strain in the current circumstances of the pandemic. Recognising the power to cancel the visa under subsection 133C3 of the Act is discretionary, I have taken into account Mr. Djokovic's circumstances in determining whether there are factors that would support a decision not to cancel Mr. Djokovic's visa. Mr. Djokovic was granted a Class GG Subclass 408 Temporary Activity Visa on November 18, 2021 for the purpose of travelling to Australia to participate in the Australian Open, which commences the 17th of January 2022. I've taken into account that Mr. Djokovic's visa was granted for a specific purpose to enable him to take part in a time-limited elite tennis tournament. I find there is no information to indicate the purpose of this travel has changed, and give this consideration some weight against cancelling his visa. Mr. Djokovic's Class GG Subclass 408 Temporary Visa was granted subject to Condition 8107 Work Limitation and Condition 8303 Activity Limitation. I note Mr. Djokovic has an extensive compliant travel history with no evidence of non-compliance with previous visa considerations. I give this consideration some weight against cancelling his visa. Here we go. I'm aware that the Australian Travel Declaration for Mr. Djokovic has a false answer to question 2. Redacted has provided a statutory declaration to say that it was her fault and that she did not check the answer with Mr. Djokovic. I will assume that to be true. Mr. Djokovic said in his affidavit in the FCFCA that he authorised his agent to submit his Australian travel declaration to the Australian Government Department of Home Affairs. While I will assume that Mr. Djokovic has not breached any laws in circumstances where his agent says she's to blame, I'm still concerned because Australian travel declarations are important documents, and the information in them should not be false. Mr. Djokovic's Australia travel declaration had a false answer. Mr. Djokovic should have been more careful. The circumstances of a false answer on the Australian travel declaration do not weigh against cancellation. Those circumstances are at most neutral, although I'm minded to give it some small weight in favour of cancellation. I do so recognising that the Australian travel declaration is separate from a visa application process. My decision would be the same, though, even if I did not take the false answer on the Australian travel declaration into account. I consider that the cancellation of Mr. Djokovic's visa is likely to cause him and his family some significant inconvenience and emotional hardship and distress, and is likely to result in significant reputational, financial, and professional implications for him, including his inability to compete at the Australian Open. Given the hardship caused by Mr. Djokovic by a visa cancellation, I give this consideration some weight. Against the visa. There's no record of any adverse behaviour by Mr. Djokovic towards the department, nor is there any information to indicate that he's not previously complied with his obligation. Indeed, Mr. Djokovic has been cooperative in his dealings with the department. I give this consideration some weight against cancelling the visa. In addition, as mentioned in paragraphs 15 and 16 above, I weighed the issue against whether Mr. Djokovic entered Australia consistently with the target documents, as well as the fact that he considered that he had a valid medical exemption to come to Australia and that he would therefore be entitled to remain in Australia as a factor against cancellation. There are no consequential cancellations that may result should Mr. Djokovic's visa be cancelled. Consequently, I'm unable to give weight towards or against cancelling Mr. Djokovic's visa when considering this factor. I've considered the legal consequences of a decision to cancel Mr. Djokovic's Class GG subclass 408 visa, and that he may be an unlawful non-citizen and liable for detention pending removal from Australia. The cancellation of Mr. Djokovic's visa would enliven Section 48 of the Act, significantly limiting the type of visas Mr. Djokovic could apply for while he is in Australia. In addition, for a period of 3 years from the date of cancellation of his visa, Mr. Djokovic would not be able to be granted any class of visa that is subject to public interest criteria 4013, except in certain circumstances, but not limited to compelling circumstances that affect the interests of Australia. The exclusion period will be considered as part of any new visa application and can be waived in certain circumstances, noting each case to be assessed with its merits. I have considered that Mr. Djokovic regularly travels to Australia to play in tennis tournaments and would need to declare his visa cancellation as part of the visa application process, which may affect his ability to be granted a visa to enter Australia in the future. I consider the above consequences significantly. Consequently, I give this significant weight against cancelling his visa. I am not aware of any international obligations that would or may be breached as a result of cancelling Mr. Djokovic's visa. Mr. Djokovic is a national of Serbia and has previously resided in Serbia and has not expressed any concerns or issues with the department that would give rise to any international obligations to which Australia is a signatory. Consequently, I regard this consideration to be neutral. I am aware that the Serbian government has expressed its strong support for Mr. Djokovic to remain in Australia, and that it may react to the cancellation of his visa. According to media reports, Serbia's Prime Minister says her government will be willing to guarantee that Mr. Djokovic will respect local regulations if he's allowed to stay and compete in the Australian Open. I give these diplomatic considerations some weight against cancelling the visa. I accept that there are some factors in favour of a decision not to cancel Mr. Djokovic's visa. However, I consider these factors are outweighed by either the public health or the good order considerations considered separately and independent from each other, as discussed above, together with the public interest considerations above. Even if the factors discussed above, which I have identified as other considerations, are properly understood to form part of public interest, my conclusion that it is in the public interest to cancel Mr. Djokovic's visa would remain the same. I would still consider it in the public interest to do so. After considering all the matters expressed above, I am satisfied the reasons for cancelling Mr. Djokovic's visa outweigh the reasons not to cancel the visa. I have therefore decided to cancel Mr. Djokovic's class GG subclass 408 temporary activity visa under subsection 113C3 of the Act. And then they've got this, and then this is what happens as soon as possible. This was what he had to do. Recommendations. So and then here's his considerations again. Again, that's the official documentation. Look. It's all here, and then all the attachments. All right. So, dear Mr. Hawke, foreshadowed consideration. So here is we act for Mr. Djokovic. So here it is. They're putting their case forward as to why he shouldn't get deported. So and they've put, you know, so that's what they've put in there. So this is their case that they've. So this is the information that they put forward to the minister. So it says, should the Minister for Immigration purport to cancel Mr. Djokovic's visa under Section 133C, we hold instructions to immediately apply to the courts for relief. We've sought instructions to seek an urgent final trial. Judge Kelly is already well aware of the issues. In the meantime, we request you take all appropriate steps to ensure that the Minister is available for cross-examination at short notice in the event that the Minister purports to cancel Mr. Djokovic's visa. We anticipate if such a decision is made, then proceedings will be commenced forthwith, and that will ask the court to conduct a final urgent hearing and issue a subpoena to the Minister to attend to give evidence. So also, they were going to, so essentially the undertaking was that they would alert the court 30 minutes before the decision was made. There'll be no attempt to remove Djokovic for 24 hours after notification, and then how to notify them. So that was that one. The Tagi stuff. Then we've got the first affidavit. This was against the Minister of Home Affairs. So this was the Chief Medical Officer. This was part of the stuff. So she's got a Bachelor of Medicine, Bachelor of Surgery from the University of New South Wales, and a PhD from the University of Sydney. And so now she's talking about the review system. Okay. And then this is the medical exemption from COVID vaccination. To whom it may concern, he's been provided with medical exemption from COVID vaccination on the grounds that this individual has recently recovered from COVID. The temporary exemption is valid until the 16th of the 5th, 2022. So, provided by independent. So, hang on. This is from Tennis Australia. All right, so that was the, and then these are the public cases, COVID cases. Look at it. This is from Serbia. So, COVID results. This is something here. Immigration Minister has the power to move under a Monday night. Spokesman for the minister is currently considering, should NOVAK Djokovic be allowed to stay and play in the Australian Open? 60% said yes, 37% no. So that's why they're saying lots of people said. Using a Sydney Morning Herald poll. This is an AGS lawyer. So this is the government lawyer, I think. AGS, Australian Government Solicitor. So they've got here the interviews. She transcribed the transcriptions. And then we've got the transcript of the interview. I'm going through slowly so you can pause, because I mean there's 200 pages here and we've been going for like over an hour, so I don't want it to go for too long. But they're just a lot of exhibits. All right. At the end of the day, tomorrow, we're going to find out. I think they're prepared to sit. From my understanding, they are prepared to go all day and for a decision to be made tomorrow. But if they do the full court, it'll be interesting to see when the decision's made. So this is the next one. So see, what I want to know is how he got his vaccine. If he applied for his visa in November, he was unvaccinated and he hadn't had COVID. I want to know how he got his visa in November if he didn't meet the criteria. Oh, Serco. Oh. Okay, so we got this. So there's the interviews here. So you can go to the federal court site, click on public interest cases, and it's sitting there. So here is the Australian travel document. Enter your intended length of stay in Australia, 27 days. Are you transitioning through Australia to another country? Within 40 days, travel to another state? No. Have you ever received a COVID vaccine? No. In a way that the medical exemption itself covers. Yeah, it is, isn't it? So again, that's a medical exemption. Not a lot of transcripts, which is totally expected, but I'm still enjoying. Oh, look, I'm loving it too. I'm just really annoyed that I'm somewhere else tomorrow morning. I'm only going to catch the second half of the video. I'm really enjoying it. So this is the next lot. Why couldn't I have made it for the afternoon into the night? I would have been right. I would love to be working in the National Tennis Centre at the moment, watching Tennis Australia put their plans into action. So again, here's all the stuff. Me three boys enjoying it too. Yeah. So some of these are repeats by looks, because this was. I have to say, I mean, he did go into very much detail as to everything that he considered. And it looks like the biggest, this is from my view, that the fact that he was out and about in public after testing COVID positive, I think, is one of his biggest factors. I mean, I may be wrong, but, and that's the one that's angered a lot of people, is the fact that he was out and about COVID positive. So a lot of people have really been really angry about that in Australia, you know. Again, we've got the same letter. Again, so it's just a repeat of documentation. Advice from the health of here's the advice that he got. Restrictions in Victoria, so they need to must have an international COVID vaccination certificate of valid following, and must present evidence of a negative PCR test taken within 3 days of departure, and get an international passenger arrival form from the Services Victoria. Noting these arrangements are separate to Commonwealth arrangements for travel exemptions and visas and completion of the Australian Travel Declaration. Did he have a negative COVID test before he entered Australia? Non-vaccinated international arrivals must quarantine for 14 days in a hotel or at home if they have a valid medical exemption. So according to this, what I can see, he should have had to have been isolating. Okay, he did. Okay. Hey, I'm totally out of it at the moment. I got no idea what day it is. No, it's some Saturday, isn't it? All right. So only fully vaccinated people can attend sporting events, recreational facilities, and sporting events. On the assumption that Mr. Djokovic tested positive on the 16th of December, tested negative on the 22nd of December, and was asymptomatic from at least the 27th of December, and that he's unvaccinated, what is the nature and degree of risk that he presents to others? And then here's the answer. If he presents a risk of infecting people, what are the risks? All right, so please assume all Australian Open patrons aged over 12 years, 2 months will be fully vaccinated. Patrons will be asked to check in using the Service Victoria app and show their digital vaccination certificate. We do. We actually, even the staff, we have to show quarantine will say people with medical exemption. They go, yes. I know. I don't like that either. The terms and conditions may withdraw an attendee's right to attend the AO and access Melbourne Park if the attendee tests positive for COVID, is identified as a close contact, is in the process of completing government mandatory self-isolation, present with COVID symptoms. All patrons aged 8 years and over are required to wear a mask. We assume that employees at the AO should be vaccinated based on... Yes, we are. We weren't allowed to work there. What are the risks arising from their infection? And now this is what has been said about vaccines. See, and this is the thing, anti-vaccine activists have rallied to support the Star. So this was from, what date was that? That was BBC News. So advice from the Department of Health. A Tigey statement. Recommendations, background consideration. That's the actual advice. Then we've got all the COVID stuff. The old Parliament House. Oh, cool. All right, we'll have a look at that in a minute. Has he decided whether it's a full court? We already know this info, but the order is out. Okay, cool. Has he decided whether it's a full bench, though? So this was the 12th of December. So, yeah, he's using the fact that there's lots of... You're halfway through. Not yet. Okay. Serbian PM condemns Djokovic's breach of public health orders. So there you go. Hey, poppy seeds, there's a troll for you to deal with. I am for you to do a troll. So that's that one. Then this is his this is Djokovic's statement where he's admitted the error of judgment. I think, in my opinion, that would be the most damning bit of evidence, his own words. Yeah, a mod action to do. Okay, so more articles, news articles. So we're only halfway through, and then again, he's highlighted some bits here. Okay, attachment P. Serbian minister offers guarantee Novak Djokovic will abide by Australian law. And another affidavit. Oh, again, they're just repeating the same documentation because we've just seen that one. So we'll go through that one. What's that one? Oh, yeah. We've seen all of this. Oops, what's this one? Foreshadowed cancellation of visa. Yep, we've seen that one. Apparently 60% people want Djokovic to play. I think you'll find that those people want to boo him. Just my opinion. Another one, again, another repeat. They're repeats. Seen all this. Atagi stuff. Okay, some more information, some more correspondence. Again, all the journal documents that they've got that they're sending him, all the emails. We now of agent in relation to Djokovic's travel documentation. So somebody said I've made the mistake, and then they've put in all these stuff to talk about COVID. Okay, so a lot of journal articles. All right, oh, we're nearly done. Encloses a bundle of scholarly articles are footnoted below which support the responses set out in this letter. So, again, that's the letter. So, everything's here. I'm wondering what people are thinking about. I mean, I know we're not lawyers. Well, one of Poppy Seeds is. What your thoughts are from what you've seen. Do you think that they're I am currently engaged as his agent. I've been doing for 11 years. As part of my work for Mr. Djokovic, I managed his travel arrangements. In January 2022, I was involved in making arrangements for Mr. Djokovic to travel to Melbourne. On the 1st of January, I completed and submitted to the Australian Government Department of Home Affairs an online travel declaration form on behalf of Mr. Djokovic. The online service managed by the Australian Government. Question 2 asks whether the traveller has travelled or will travel within 14 days prior to their flight to Australia. I answered no to that question in completing the ATD for Mr. Djokovic. This was a mistake. I did not check with Mr. Djokovic the correctness of my answer to question 2. Hang on a minute. But if this person does all their travel arrangements, he would have known that he was going to Spain. They wouldn't have known they were going to Spain, wouldn't they? It was recently highlighted to me that Mr. travelled from Serbia to Spain on about the 28th of December. On this basis, I realised that I should have checked what I thought was the correct answer. Yes to question 2. My error in answering question 2 was inadvertent and unintentional. I recognise I'm deeply distressed, sorry, and embarrassed for this error. All right, so that, now we've got, this is the originating process from before. You don't think so? This is this the Djokovic? Oh yeah, this is his, the applicant in proceedings. So this is his affidavit. So anyway, you reckon? Okay. So this is the visa. Again, we've got this. These are all the attachments that are all being signed. All the attachments have to be signed. We have received Australian declaration. So it says that you are required to undertake a test within 24 hours and again on day 6. Okay. Then we've got a border travel permit. So it's a border travel permit. So he only had an exemption to be in Victoria. He didn't have an exemption to get into the country, from my understanding. This is the intention to cancel the visa and the reasons why. Okay, yeah, we've gone for nearly an hour and a half. So we'll check out the orders, which we already know. Look at the timelines, and then I'll head off, and then I'll update you once we hear whether that we've got a full court or not. Apparently he refused to sign. So he refused to sign. Alrighty, so that's that one. So, okay, so here we are. Let's see. So we've looked at all of those documents so far. I'm just going to refresh this. Did you say the orders were out? Well, let's go here. This is the actual file. Immigration review. Oh. I haven't got it. Or do I need to go to the actual orders judgment section? You go here for a minute. There's the ABC's actually put a link to the website to say, hey, if you want to read the documents, they're here. Okay, you'll send them to me. Okay, cool. All right, thanks, Poppy Seeds. Yeah. Oh yeah, that's the one that I wanted. All righty. Oh, you mean Judge Kelly? I went through Judge Kelly's orders this morning. My first one, yeah, we did that this morning, I think. I was hoping for Justice Callahan's, but probably be a bit early for that one. But yeah, the time frame is lunchtime. In fact, Djokovic's stuff should have been done by now. Then 10 o'clock tonight, the government will have their stuff ready. And then, yeah, they'll be ready to go. Oh, okay. No, it's Callahan's. Okay. Oh, okay. Really weird. It's not showing up for me here. The link that you sent me took me to Judges. Okay. All right. Thank you, Poppy Seeds. All right. Here we go. Here are the orders. So we'll finish up with this. The orders for from today. And then, as I said, we're just waiting to hear whether it's a full bench now. All right. So these were the orders from today. So that the transfer of this proceeding to the Federal Court of Australia from the Federal Circuit and Family Court of Australia made by Order Judge A. Kelly on the 14th of January 2022 is confirmed. The applicant filed and served any amended application by 12 noon the 15th of January 2022. The applicant filed and served his written submissions by 12 noon the 15th of January 2022. So their submissions should have filed. The respondent filed and served his written submissions by 10 p.m. the 15th of January 2022. So that's happening tonight. The proceeding will be fixed for hearing 9:30 tomorrow on the 16th of January and costs reserved. So there you go. That's where we are. That's where we are at the moment. So as I said, it is a public online file because it's a public interest matter, and they're trying to get them updated. I will also assume, there you go, 9:30 a.m. Sunday the 16th of January 2022. The hearing will be streamed live from the Federal Court's YouTube channel. I'll probably only pick it up halfway through the day because I'm actually at church. And then I've got to go and do some stuff for my grandma's funeral. So I will be, in and out. So I won't, unfortunately, get to see all of it, but I will do my best to be online once we've got a decision. We're still waiting to hear whether or not we've got a full court or whether we've just got a judge. As I said, with the full court, it was acknowledged that the appeal procedures would the prospect of being able to appeal is very slim. It's easy to appeal with one judge. So if, for example, the court decides to go for a full bench and Djokovic loses, he essentially is out of the country. So, if the minister loses, then it's likely that, it's unlikely that they can appeal. They won't appeal. So anyway, that's where we are with this saga. Anyway, thank you for joining me. Thank you, Poppy Seeds, for your expertise and explanation. As I said, that's all it is. I know you all know my views on the matter. I don't think he should be here. I don't think he should be playing, but that's me. That's my personal opinion. So anyway, that's where we stand. So thank you for joining me, and I will catch you again when we've got another update. Who knows? I could have 5 or 6 live streams today as this saga continues, hey? Anyway, I'll catch you all later. Bye for now.